I am excited as always. We have a guest speaker today, and guest speaker is great. One of my favorite guest speakers. I don't say that about every guest speaker, but this one is a terrific attorney. So I'm excited about that. I'm excited about what we're going to do. We're getting deeper and deeper into the actual legal writing part of the class and the nuts and bolts of memos and things like that. So I'll do housekeeping. I will do practice tip of the day. I'll explain an assignment that we're going to do and also kind of preview it a little bit. We'll talk about the readings that you did for today. There were a lot of readings, not especially long readings. The Garner one was kind of long, but there were a lot of readings. We'll talk briefly about the deep issue statement, which you're going to be reading about for next class. We'll practice it a little bit. We may do a Garner game, and then we have Kate Crosby as our guest speaker today. So let's see. It seems like there was some housekeeping thing I was going to tell you, but I didn't put on this list. Okay, so we don't have class on Wednesday, as I said in the email, and so a reminder, we are making it up by extending 5 minutes to each class throughout the rest of the semester. Homework for Friday, please, that's a week from today. Please read Garner section 22, and then read this case, Smith v. Kane, which I'm going to tell you about later and tell you how to find it. And then use the guidelines from this Garner reading to write a deep issue statement for Smith v. Kane. So I'm going to explain all that in more detail later in the class. And then read Judy Fisher, page 40 to 44. You can skip the last paragraph of page 44. What else? I know I'm forgetting how. Okay, practice tip of the day, which you don't have to worry about whether I follow this practice tip of the day in practice or not, because I don't have to do any of this anymore, this part. But if you have a question about court rules, call, and you can't find it online, don't hesitate to call the clerks. If you have a question about research and you can't find it online, don't hesitate to call Lexis. There's kind of this habit, I fell into it when I was practicing, that now that there's an internet, you should at all costs avoid speaking to another human being. Yeah. Sometimes that can be a waste of time to spin your wheels when you could just pick up the phone and get an answer to your question. So don't hesitate to call the clerk of the court, which by the way is a different office than the clerks of a judge. The clerk of the court is like a career person who makes everything work. And then don't hesitate to call Colby at Lexis. You'll meet Colby later in the semester. But Lexis has, whether you call Colby or just their 24-hour 800 number, they can help. And you can do that as a student, and you can do that as an attorney. Okay. Next up is we'll talk about this case that you're going to read and then write a deep issue statement about. And I love this case for lots of reasons. For one thing, it was a case when I was clerking, so it's near and dear to my heart. For another thing, it's just an outrageous example of bad lawyering at the trial level. And then by the time it gets to the Supreme Court, it's almost as bad lawyering at the appellate level. And you'll see in the opinion how bad the trial lawyering was, and then you'll see at the Supreme Court argument we're going to listen to about a minute of today, how bad that was, and and then it's also a fairly basic case in terms of learning how to do a question presented. So why highlight bad lawyering? Because I think you can learn as much by seeing other people's mistakes and then saying to yourself, I'm going to avoid that, as you can by seeing great attorneys do great things and say, I'm going to copy that. You should do both, and all throughout the year we'll do both. So let's start with a just description of this case, Smith v. Kane. It's a murder case, and the defendant Smith was identified by a witness to the murder named Boatner. Right? So there's this guy Smith, there's this guy Boatner. Boatner tells the police Smith did it. And they go to trial, Boatner testifies, you know, it's like the typical, like, is the murderer in the room, in the courtroom, and the witness points to Smith and says, yes, he's sitting right there, that's him. But here's what the defense did not know, and why did they not know this? Because the DA's office in New Orleans, which is notorious for this kind of malfeasance, the DA's office in New Orleans, and by the way, I'm not an anti-prosecutor. I think most prosecutors take their duty to disclose very seriously, but the New Orleans office is notoriously awful on this. So the DA's office had police notes where Boatner, the witness, had said to the police, I could not identify anyone. That's not a great thing for an eyewitness to say. I could not identify anyone because I couldn't see faces. Just like if you think about it, an important thing to see. Boatner, the witness, also told police, with regard to the criminals, I would not know them if I saw them. Would not know them if I saw them. So this was all in the police notes, and the way the law works is that the prosecutor's office, the DA's office, has a constitutional obligation to disclose evidence favorable to the defense, and it's a constitutional violation if that evidence is material. Material means reasonable probability it would have made a difference to the outcome at trial. So if you're a prosecutor, you don't have to worry about that last prong, the materiality prong. You just, if it's favorable to the defense, you have to disclose it to the defense, period. Then if you screw up on that, the defendant is entitled to a new trial if it turned out that it was material, that evidence was material, reasonable probability of a different outcome. Good morning.
I know.
So so they didn't, and he gets convicted of murder, and it goes to the appellate court, makes its way to the Supreme Court, and where's my article? The argument does not go well for the DA's office, and you can tell just from the title of this article, which is called Argument Recap, Disaster at the Lectern. So, not a great day for the DA's office. Here, I'll read you a few sentences from it. There may be many ways for a lawyer to realize that an argument before the Supreme Court is falling flat, but none can top this, a justice asking if the attorney had ever considered simply giving up the case. So, imagine if you're like at an oral argument with the judge, and you're answering all these questions, the judge just leans over and is like, let me ask you a question. Did it ever occur to you that your argument is so unwinnable, you would just save yourself some time if you just give up? Not a great sign that things are going well. This is what happened to the assistant district attorney as her argument lay all about her in shambles. It's a heavy burden for a lawyer in that oft-criticized office to mount any defense, but she repeatedly found ways to botch virtually every point. As she argued, Smith became. It goes on and on. I won't read you the whole thing. It's great. It's great, though. The aggressive exchanges were getting to the attorney, and the phrase, I'm sorry, began appearing regularly in her answers. Justice Elena Kagan leaned forward and asked, Ms. Andrew, did your office ever consider just confessing error in this case? So that's a way of saying, did you ever consider just giving up? Stunned, the prosecutor said, I'm sorry. Question mark. Did your office ever consider confessing in this case? You've had a bunch of time to think about it. True, months. Do you know? We took cert a while ago. That's a way of saying we decided to hear this case a while ago. We let you know a while ago we would be doing this argument. I'm just wondering whether you ever considered confessing error. Let's listen to it, and then let's talk about, like, I think a lawyering skill lesson, even beyond, like, don't suck at your job. Yeah, so let's see. Here we go.
So worried that the car that he arrived in had no license plate. They were definitely looking not to be identified.
Ms. Andrew, did your office ever consider just confessing error in this case?
I'm sorry?
Did your office ever consider just confessing error in this case? You've had a bunch of time to think about it, you know? We took cert a while ago. I'm just wondering whether you've ever considered confessing error.
Your Honor, we believe that we have an argument that these statements of Larry Boat.
What happened? You know what?
Buffering. Thank you.
Sponsor not secure. Let's see here. It's alright, she's not gonna get off that easy.
Do you have a log sponsor?
No. My computer just always gets confused. It does that. It's so annoying.
You can
Oh,
fix that.
was
trying to connect to sponsor.
Can you help me after class?
Yeah.
Thank you.
Please do it.
Because I forget. As you've noticed probably by now.
People who know computers are great.
I know. One year a student basically like saved my computer from crashing and losing everything.
That's great.
Okay.
Ms. Andrew, did your office ever consider just confessing error in this case?
I'm sorry?
Did your office ever consider just confessing error in this case? You've had a bunch of time to think about it, you know? We took cert a while ago. I'm just wondering whether you've ever considered confessing error.
Your Honor, we believe that we have an argument that these statements of Larry Boatner are not material. The other evidence that Mr. Shanmugam has put before this court were either not suppressed or not favorable. Larry Boatner gave several, he did describe Juan Smith.
I'll stop waiting there, but you get the point. So here's what do you think are some of the mistakes that this attorney made in getting to this point? Not things she actually did wrong in the argument, but what do you like? What are some off ramps that she elected not to take before this argument even started?
Maybe like looking at like common law to see what material risk was.
Yeah, maybe having a better understanding of what materiality and the material test is. Yeah, and maybe another way of saying that is just in a more general sense that would apply to any case you ever do, being prepared. Like, she may well have been prepared enough to do like a 4-minute like TV show interview, like, you know, on Conan O'Brien's show or something like that, but she was not prepared for a 30-minute inquisition, diving deep into what the law is. And that doesn't come across entirely from the clip we heard, but just was not prepared. So that's one mistake she made before the argument started. Another mistake she may have made before the argument started, which Justice Kagan is getting at, maybe there shouldn't even been an argument. Maybe you just like confess error and forfeit the case. And why would that be, aside from not embarrassing yourself, why would that be better than doing the argument? One reason is that if you confess error, you only lose this case. But if you let this go to a decision and it gets published and it gets put in a casebook, it doesn't really matter if it gets put in a casebook, but that can change the law in a way that's even worse for you than losing this one case. I mean, what if the judges are so outraged by your misbehavior in this case that they rewrite the law that make it even harder for prosecutors to like win cases in the future? So you should always be thinking about not just the case you're litigating, but its effect on future cases, and in particular, don't just be thinking about what's in the client's interest for this case, but what's in your client's interest more broadly than that. And we have some great guest speakers this year who talk about viewing clients' interests not just through the narrow lens of winning this particular case. So, and then the third, I think, lawyering skill lesson from this, which is actually the main reason that I play it, is that not every lawyer is great at everything, and you shouldn't feel bad if you're not great at everything. If I tried to do everything a lawyer does, I would be bad at much of it. Like, if you asked me to like write a mergers and acquisition like agreement contract between like two Fortune 500 companies, I would have no idea where to start. I'm sure I would commit malpractice. This attorney may be a great trial attorney, or maybe she's the kind of like the DA in charge of the whole office, and she's a great leader and policy thinker, but not a great like nuts and bolts trial attorney. Regardless, she's clearly not a good appellate advocate. She's not great at this back and forth with judges thing. And so what she could have done is just ask someone else to do it. That would not have been hard. There's probably someone in her office who is better at this. There's also attorneys all across the country who would do this case for free, because attorneys will do a Supreme Court oral argument for free. It's good for their resume and their credentials. They make more money in the long run by doing it for free now. So she had all these options, and there's a case in Louisville that a similar thing happened. So has anyone ever heard of the murder trial of, now I'm blanking on the name, Mel Ignato? Does it ring a bell at all? Yeah. So Mel Ignato brutally murdered a woman, and Ignato's girlfriend, I think, witnessed it. And so it was a huge case, and the prosecutor in Louisville, the Commonwealth attorney, it's now Tom Wine, but Tom Wine is great. It was not Tom Wine at the time. He decided he was going to try it himself, which is very rare. Like the Commonwealth attorney runs for office. He manages, 20, 30, 40 attorneys, whatever, in his office. Does budget stuff, does big policy stuff. Usually doesn't like to try an actual case. But this Commonwealth attorney decided he was going to try the Mel Ignato murder. Why do you think he decided to do that? Let's not give him the benefit of the doubt. Yeah.
He probably just wanted to kind of boost his public persona.
Yes, exactly. He did it for the attention. He did it because he thought it would make people, it might help him with his reelection, whatever it is. But he probably did not make the decision based on who is the best trial attorney in this office. I'm going to assign that person to do this case. He took it for himself. And that was a mistake because he did it poorly and he lost the case, and this guilty person went free. Anybody know the rest of the story?
I don't even know the
They found her body under his house. I remember that.
Yeah, but I think that was before the murder trial.
Oh, really?
But they later found, I don't know if it was under his house, but they later found, after the trial, after the acquittal, they found pictures in his house
there we go.
of the murder. And by then they couldn't try him again because you can't try someone twice for the same crime. But they did try him for perjury because he had testified at trial. So
He died mysteriously on the same coffee table where she was murdered.
that is also true. Yes. So for all that, he served time in prison for perjury. He eventually got out of prison, and then
His house was like
not too
right
long
next
after
to
that,
Yeah.
was found
Somebody, I think.
was found
helped
dead in
it
very
along.
mysterious circumstances. So karma happens, but no, not necessarily. I mean, I'm not saying he deserved to die, but he did deserve to die. So in any event, that attorney in Louisville, and now I'm blanking on his name, but he should not have tried that himself. This attorney should not have done this oral argument himself. Know your talents, don't doubt yourself, but also know your limits, and don't be afraid to ask for help. Okay, so if you go to Lexis, I'll walk you through how to do this, and you can do this at home. But I want you to, first of all, this will be nice practice, doing Lexis on your own for maybe the first time. So you go to LexisNexis.com, click on Lexis Advance, and then you will type in this. Do. Show what you were at, Zach. 565. Look at this. Marker works great.
Woo!
So exciting.
This room has the best markers in the building.
So you type in that citation, and we'll do it right here so you can see what will happen. Then 565 US 73. And it will take you to Smith v. Kane. Read the majority opinion. It's one of the shortest, it was probably the shortest majority opinion of that Supreme Court year. Don't read the dissent. The dissent is long and not persuasive. Can you believe that? It was 8-1. So based on the facts I just told you, this witness, remember he said, I wouldn't be able to identify anyone if I saw them. Prosecution doesn't disclose this to the defense. Guy gets convicted. Still one dissent. One dissent says, it still didn't matter. The guy should not get a new trial. So, want to guess on who the dissenter was?
Was it Roberts, because you hate him?
Roberts writes the majority, but I do hate Roberts. So Scalia is a likely candidate. It wasn't Scalia, it was Thomas. Yeah. Thomas is tough. It's tough. There's also a great moment in this oral argument where they were talking about grills, and because I guess one of the murderers had grills, and so that was part of like what had or had not been identified. And none of these justices knew what grills were, except Justice Thomas. And Justice Thomas then, like, who doesn't speak an oral argument, but he has his clerk get a picture of a guy with grills on his teeth, and he passes his picture around, and he's laughing. He loves it. He loves it. So, okay. So read the majority opinion. It's short, and then write a deep issue statement for it. And what that means is you will write a question presented, and you will write a short answer. Question presented is where you describe the legal question. Short answer is where you answer the legal question. Each of those should be in the range of 2 to 3 sentences.
Can you repeat that one?
Yep. Write a question presented and a short answer. The question presented, you describe the legal question. And the short answer, you answer it shortly. And we're going to spend most of the rest of the class talking about what that means and practicing it. Yeah, great.
Is this something that you're gonna collect, like, do you want us?
Yep, email it to
do, like-
Gmail, please, and bring in a hard copy. And, you know, this is a little bit of an artificial exercise because when you do a legal memo with one of these deep issue statements, you will not know for sure how the case turns out. In this matter, you know for sure how the case turns out. That just means you're going to get the short answer correct. The court has already told you what the answer is. Okay. Questions about the assignment, questions about Smith v. Kane, questions about the New Orleans DA's office. Don't get arrested in New Orleans. That's the ultimate lesson of this class, especially if you're innocent. Yeah.
Isn't that where our guest speaker was from?
Which one?
The, well, oh, yeah.
Who?
At the oath ceremony.
I don't think she moved there to do, because New
Oh,
Orleans,
Stephen Riley, right? Was he your guest speaker?
there's a woman and a man.
She works in Indiana right now for the DA.
But I thought originally she said
She-
she was a prosecutor.
She went to
Yeah,
New
she said
Orleans
she was-
because is high in crime. That's what she was looking at. Because I think in
Junior's father.
Yeah,
It
he
was
was
Jennifer.
he was the DA for most of this. Like,
oh maybe.
I don't know her name. And just because she may be a terrific attorney, just because you worked in a corrupt office doesn't mean that you're corrupt. But Harry Connick Jr. father was just a terribly corrupt DA in terms of like violating this due process law. What'd you say?
She just said, I feel like there's drama.
Drama where?
And then, because she was our guest speaker, and then you're like, it's a corrupt office.
She probably agreed. And if she doesn't, she's corrupt.
That's how you know.
You know, if you ask
She did seem a
Tom
little-
Cruise's character what that firm was like in Memphis, I'm sure he would tell you it's not terrific. What did you say?
She was a little like
Yeah.
Out there?
Yeah.
Politically or in
No,
style?
she was just really talkative and a little weird.
I don't understand why they had 2 guest speakers.
It's kind of like she
either.
got up there and just
He-
was
Am I-
swinging it. I think the guy was supposed to speak at the graduation.
Oh, yeah, so they had him like,
They had him come for
that
this.
was just,
Yeah.
he couldn't do the graduation last spring, so they had him kind of just as a second thing, I guess.
Okay.
He spoke really
Sure.
Yeah, he spoke for 2 minutes.
Yeah.
I thought she
Wow.
was.
He was some judge. Was he a judge?
No,
He
he
worked
was
for Frost
like,
Frost.
partner with Frost Tower.
She didn't.
No. I was like, hey,
I know.
she's like 50
He was
something.
very like what you would expect. She was kind of out there.
How did Logan do, the SBA president?
She did good.
Started the speech off with, if you asked me what I would, if I were going to be in front of a speech 3 years from now, I would have told you never. So that's how that went.
That's not bad, is it?
That's trite.
Wow. It's tough. All right, well, Logan's terrific, and no one's ever allowed to criticize Logan, so. That was
We're friends, first of all.
That was a mistake. So I heard it was great, but that was from Logan. Just kidding. Okay. All right. Let's talk about the readings that you did. Emily, tell me what the Brian Garner Section 21 reading is about.
Get back to it.
193, I think, or 190 something.
69.
Oh, 69.
Just tell me anything about it that would let me know you read it.
Unfortunately, that's the one I didn't read.
Which one? Which one are you talking about?
So, Section 21.
Oh,
Sorry.
Section 21.
Sure.
What's it about?
It's about planning out your writing as like a 3-step process, or each of the 3 parts.
Yep.
Beginning, middle, and end.
That's it. Beginning, middle, and end. So Phil, and you can paraphrase, I'm not asking you to have memorized it, but he says, more than anything else, this explains why so many briefs are inadequate. So do you remember, like, and you can phone a friend on this if anyone else remembers, he says, this is the main reason why so many briefs are inadequate. Yeah.
They
Bailey.
don't have like a beginning and an end, it's all middle.
Yeah, no logical structure. So now we've heard Steven Pinker say the main reason bad writing is bad is because of cursive knowledge. Hear Brian Garner say the main reason that legal writing is bad when it's bad is a lack of structure. You know, it's not to say that one of them has to be wrong. It's just actually to say, like, don't forget the cursive knowledge, and don't forget to have a logical structure, and if you take care of those 2 things, you're going to be well on your way to avoiding the main mistakes that legal writers make. What do you think this has to do, this EG 21, this Brian Garner 21 section, with the cursive knowledge? Let's kind of like go for a full circle a little bit. What he says something, yeah, Alex.
An introduction kind of like levels into the, bringing in the topic more than just getting into depth, so it makes it easier to translate.
Yeah, exactly. If you just like don't do beginning, middle, and end, if you just like dive straight into the middle of the middle, it may be a great way to like make a suspense movie or something where you start in media res, right in the middle or something, what's going on. But that's not how you do a legal memo. That reader is not going to know all the things that you know, and if you don't set it up properly and lay the foundation, that reader's just going to be confused. Okay, and does anyone remember this Samuel Johnson quote that Brian Garner mentions? What is?
Oh, never mind. I had it, but
you remember the whole
have
quote?
To look. I thought I did. I had
you
it
can
this
paraphrase
morning.
it. I wasn't asking if anyone memorized the quote. That would be really something.
Well, I got it now. Never mind.
You got it?
You want to read it?
Yeah.
Oh, okay. What is written without effort is in general read without pleasure.
Great.
I
Great.
did like it.
You like that?
Yeah.
I like it too. Dimitri. So it reminds me, there's a Lincoln quote where he says this would have been shorter, but I didn't have time. And so, you would think like the more rushed you are, the shorter something will be, but actually it takes time to make something clear and concise and, throw out all the waste and just have in there what's most necessary. So it's a process. Editing takes time, writing takes time, outlining and planning takes time. And when you do that, when you put forth the effort, it makes for a more pleasurable read for your reader, as Johnson says. What's written without effort is in general read without pleasure. So let's, especially one of the people who had their hands up and didn't get to read the Johnson, I feel sorry for you because it's wonderful to read. But I'm going to give you a chance to read something even better. If you look at page 71, we really want to read the whole thing. Maybe so. All right, who had their hand up? I think Kelsey did. Kelsey, take us to a sea change at the bottom of page 71.
Okay. Yeah, just like read it?
Yep, but with pride, with enthusiasm. Oh, awesome.
All this may sound obvious, but judging from what lawyers actually do, it's little known. Go down to the courthouse sometime and look at the filings. You'll see that more than 85% of them have stock openers and closers.
Yuck, gross. And I don't, he doesn't actually give you an example of these, oh yeah, he does kind of. The stock openers are just so boring, and they just like say to the reader, like, you don't need to read what I'm writing right now. Just like gloss over it, read over it, and it's a wasted opportunity, because if there's one sentence that you can count on the reader being most likely to read, it's your first sentence. So okay, keep going.
They're all middle. The absence of logical structure more than anything else explains why so many briefs are inadequate. Likewise, many, if not most, research memos assume that the reader is familiar with the subject as the writer.
What is that? What is that? What are you talking about right there?
The
The curse of knowledge. Why would you assume that? Why would you assume that your little kid cousin knows that there are pencils in the M&M box or M&Ms in the pencil box? Just madness. Okay, keep going.
As a result of which no good comprehensible summary appears.
Okay, that's good. We'll stop there. Great job with the enthusiasm, and so keep this in mind. Keep it in mind. It's good. We can all do it, and so many people don't, and it's just makes for really bad writing. Okay, so let's talk about the two memos. Where is Sam? Sam's back here. Who's the audience for each of the memos? And if you don't remember, take a look. But
So for Garner, I believe it's a defense attorney, correct? Or, yep, and then for the Berger? It's a prosecutor's office determining whether the case is good enough to go with.
Yep, yeah. You can use one of the nice things about a memo. You can usually tell who the audience is just by looking at the to field. But when you're writing a memo, don't forget who the audience is as you're writing the memo. Know your audience. Something we'll harp on all year long. And then can anybody think, Samuel, you can take this, or if there's a volunteer, in addition to the audience that's mentioned in the to field, sometimes there are other audiences that you might want to keep in mind when you're writing a memo. Can you have anybody else who might read this memo, Emily?
People like us who are in school.
Yeah, maybe. Poor suckers in my lawyer and skills class.
But possibly even judges who are higher up the chain in the trial court, who maybe want to see, okay, where's this going? What's this about?
Yeah, I mean, I think that memos are a real memo, unlike the kind of fake ones we're dealing with here. A real memo is going to be attorney work product, so it's actually not going to leave the four corners of the legal office, and then also the client also would have access to it. But Emily's onto something here, and that is that a lot of times the first thing an associate will do is write a memo, and then a month later, that associate's going to be writing a motion based on the memo. Or maybe a different associate is going to be writing a motion based on the memo. And so that motion is going to be read by the judge. So to the extent when you write this memo, you can do a good job for the audience in the to field, but also write it in a way that it can be useful to someone writing to a judge in a motion. Then you're saving either yourself time down the road, or you're saving someone else time down the road. And another audience that you that you might think about, not in the prosecution one, but when you're dealing with a corporate client, which is a lot, especially if you do civil defense side work. A lot of your clients will be general counsels and companies, and you may write a memo as a junior attorney to your supervisor, but that supervisor may well send that memo on to the client. So you want the memo to be not only supervisor ready, but client ready. Especially if your client is a sophisticated client, you might want to read that kind of thing. Yeah.
This maybe kind of the curse of knowledge or not knowing enough about it, but do amicus curiae people read memos at all? Or when they determine what their opinion is going to be? Or is that still circulated internally?
Yeah. Well, let's take like 30 seconds and make sure we're all on the same page about what an amicus is.
Again, I'm not sure.
So when there's particularly an appeal, but every now and then it will even be at the trial level. But let's say there's an appeal of you know, Coca-Cola versus Pepsi, okay? And now I own some other soft drink company, and let's just call it like Justin, is Fanta?
Fanta, that's a good one.
Okay, so I own Fanta. And I'm like, you know what, if Coca-Cola wins this thing, it's gonna be really bad for my business. So I'm going to file a brief with the court saying why Pepsi should win. Even though I'm not a party in the case, I'm gonna file a brief with the court saying, here's why Pepsi should win. When I do that, it's called an amicus brief, or an amicus curiae brief. So I'm not sure I don't think there's a direct connection to how legal memos work, but it's good for us to know what an amicus brief is, just as a general matter. Okay, we talked about the audience, the direct audience, but also the possibility that a sophisticated client will also be an audience. Let's take a look at Brian Garner, page 194. There's a really nice, the second paragraph, the one right after hearsay, I think is a nice example of an umbrella paragraph. So I will refer throughout the semester to, or actually throughout the year, to an umbrella paragraph, a roadmap paragraph, an overview paragraph. They all mean more or less the same thing, and here's a really good example. As out-of-court statements offered for their truth, the police reports are inadmissible unless they fall within one of the exceptions to the hearsay rule. Fortunately, two possible exceptions arguably cover these reports: the business records exception and the public documents exception. So, remember last class, we've got question presented section, the short answer section, the facts section, the discussion section, and the conclusion section. The heart of the memo is the discussion section. That's where you explain the law and then apply the law to our facts. How do you do that? You do that with a CREAC structure: conclusion, rule, explanation, rule, application, and conclusion again. This paragraph right here is a great example of how to do this first C. This C, the conclusion of CREAC, is another way of saying brief overview, a spoiler. Okay? Tell me how this is all going to end. And so this is a really nice roadmap, overview, umbrella. It says the police reports are inadmissible. There's no mystery. Telling you right now how this story ends. Police reports are inadmissible unless they fall within one of the exceptions to the hearsay rule. Fortunately, they do. Fortunately, two possible exceptions arguably cover these reports: business record exception and the public documents exception. Okay. What else do I like about this? Okay, I mentioned this last class. This memo had, yeah, Nicole.
So when he did like the three, I guess, factors or elements, are those three mini forgets?
Yep. So he's going through this business records exception. He breaks, it's actually almost a mini CREAC within a mini CREAC.
Okay.
But the authenticate, if you start at the first, let's walk through it, how it's structured, because I think it's a good question, Michaela. So page 193, discussion. He's going to do a mini CREAC for authentication. He's going to explain that rule and he's going to apply that rule, and it's not very complicated, so he does it very quickly. Hearsay, he's going to do a mini CREAC for hearsay, but it's really not so mini because it's, it's 1, 2, 3, 4, 5 pages long. So that's a longer CREAC than we will be doing this semester. But even within that hearsay CREAC, he breaks that down into a business record exception CREAC and a public documents exception CREAC and a common law exception CREAC. And of those, the business record exceptions CREAC is by far the longest. Now, that's not to say that each one of these is going to follow CREAC perfectly. In general, he's doing rule explanation before rule application. And that's the main key. But as I said last class, neither these memos are assigned because I think they help illustrate some of the good things that should be part of a memo, but they're not assigned because they are exactly how you should format your memo. For example, this memo inexplicably does not have a facts section. Your memo should have a facts section. This discussion, I think it would be nice if it began with an umbrella paragraph that just very briefly previewed that there's an authentication, there's a hearsay, and there's a, what's the third one? Opinion. So the reader kind of knows where it's going. But in general, I do think he does a lot right after.
I think he kind of did that in the last little paragraph of short answer.
Yeah, actually I see that 1, 2, and 3.
Yeah.
So maybe because it's there, he doesn't need it there. And like, I can get behind that.
Or should we put that instead of in the short answer, just throw that in the discussion?
I like the way Dimitri does it better than the way Garner does it here. So I would do the question presented like he does, the short answer like he does, but take that last paragraph of the short answer and just make it an umbrella paragraph of the discussion. But the good news for you for this semester is you will not have to guess like what to do, how to do for our 2 memo assignments. I'm going to tell you in excruciating detail how I suggest to do it. But good thinking. All right, why don't you all talk with the person next to you, and then we'll share as a class. Think about some questions. First, take a look at the table of contents of the Garner book, and in particular, look at the sections under framing your thoughts and the section under part 2. So that's sections 1 through 4 and sections 21 through 30. Now, don't read these sections, just read the table of contents and get an idea of what the sections are about. And then talk to the person next to you about these questions. What is something in each of the memos, the Barger memo and the Garner memo, that applies one of these table of contents principles? So, for example, one of Garner's suggestions is section 4. Divide the document into sections and sections into subparts as needed. Use informative headings. So I think the Garner memo in the discussion section in particular does a nice job of using informative headings and subheadings. So do that for both of those. Then also think to yourself, do the memos apply the principles in Brian Garner section 21? That's the Garner section that you read for today, beginning, middle, and end. And then finally, find something in one of the 2 memos that you don't like. Think, this made it more difficult to read, or I would have done this differently. And I think there's plenty to choose from for both questions. Things that it does well, legal writing principles that are exemplified, and then also things that I think could be improved. So take a few minutes, maybe like 5, and talk to the person next to you. Okay, Sharia, tell me what you're talking about.
Okay, cool. So we analyzed, we read through 1 through 4 and 21 to 30, and then looked at the memos and saw what it used and what it didn't use.
Great.
One of the things that we realized with the memo that we read online is that it didn't use footnotes, which I think is a problem. I like when we read the memo here, he actually states relegating citations to footnotes lets the text flow without constant interruption, and that's something that was lacking there.
Great. So a good observation, and you are quite right that Brian Garner is he's a fanatic about putting citations in footnotes. Here's the bad news, Sharia. Not for your answer, which was a great answer, but if you like putting citations in footnotes. I'm going to suggest that you don't for this class, and I'm going to suggest that you don't in practice unless you know your audience prefers it. And here's why. I actually think that he's right, that if we could like start from scratch, like make the world over again, then it would be great to train judges and partners and supervisors to look for citations in the footnotes. But your audience is going to be an audience that is used to seeing citations in the text. And they're not used to doing this, up, down, up, down, up, down. And they are more used than 1Ls are to skimming over the citations in the text when they don't want to read them, but then looking at them closely when they care. And so the judges and the partners that I've asked about this say, if you put the citations in footnotes, it makes it harder for them. And that's the name of the game. It's like, you know your audience, and you want to make it as easy for them to do what you want them to do. And in the case of writing a memo or motion, what do you want them to do? You want them to agree with you. So understand what you're saying and agree with you. So I think this is one of the somewhat few areas where I disagree with Garner, not because I think he's wrong like in the abstract, but I think it's all well and good for him to like fight this war to change how legal writing is done with footnotes. But I don't think that junior attorneys, actually even senior attorneys writing to a judge, are well served by. But you know, reasonable people disagree clearly. Garner co-authored several books with Scalia before Scalia died, and they used to go around and do this like dog and pony show around the country where they would like promote their books and try to sell books and answer questions. And it was one of the few things they disagreed about. They would argue about this question. So, okay, what else? Who's next? Kelsey. What'd you talk about? Tell me something you liked, something you didn't like.
We talked about how both of them kind of fleshed out the counter arguments.
Mm-hmm. Good. So give an example of that. Let's look at that.
Like although the arresting officer found all this stuff.
Tell me what page you're on for the Barger
The
one.
second to last. It's last one for the Barger.
Okay, last page.
The second to last.
Second to last. Okay.
And it's he just talks about how the case law establishes the principle that they can use to help them, even though the arresting officer found this.
Yeah, that's great. This is a really good example of how to deal with counter arguments, which, as I think you were saying, is one of the writing tips in the Garner book. We'll explore it more throughout the year, but you know, you'll see when we explore it more. You want to spend most of the time on offense. You want to spend most of the time telling the reader, here's why I'm right. And so you don't want to devote 80% of your brief to summarizing your opponent's arguments, because then that just like gives them space that you could be using to persuade. But you do, so that's on the one hand. On the other hand, you want to be forthright and transparent about what your opponent's arguments are and why they're wrong. So ideally, you quickly summarize your opponent's counter argument, and then you at length explain to that reader all the reasons why that argument is a bad argument. And so I think this is nicely done because the opponent's argument is disposed of in half a sentence. Right? Although the arresting officer found a cylindrical package of mints in Haney's pocket, comma, all right, now I'm done, and now I'm just going to tell you all the reasons why that doesn't matter, why I stole it. So great example of that, Kelsey. All right, let's do one more. Bryce is right here.
Hit close.
Huh?
It was like a battleship and just hit really close.
Duck.
So, we also talked about how both of them did a pretty good job of keeping things chronological.
Mm-hmm.
Like their arguments, they follow the way they were set up in the original, or whatever, opening, or the question presented. They follow the same lines, essentially.
Yep, I think they're both well structured, both in terms of doing rule explanation before rule application, so explaining the law and then applying that law to our facts. But then also just in the fact section itself of the Barger memo, again there is no fact section of the Barger memo unfortunately, it roughly follows chronological order. And you can get away with a little deviation from chronological order for your opening paragraph of a fact section. So you might say to the okay, here's a quick overview of the facts. Now I'm going to tell you the story. That's okay. But you know, how much more difficult would this have been to read if the chronology had started with a patrol car pulled up and the officer observed Haney running from the store, and then later you describe that before that happened, Haney jumped over the counter and knocked Lopez to the ground. Just like just telling it out of order, that may, just makes it harder for the reader. Seems like an obvious point. You'd be surprised. You'd be surprised. You're in the fact section. Tell a story. Start with the beginning and go sequentially, chronologically. Great. Okay. So let's do. I think I'm going to. No, we do need to do this issue statement thing. Okay, I'm going to fly through some of this issue statement stuff, in part because you're going to read about it in the reading for next class. But first, let's take a look at one of the deep issue statements that Garner has in your reading that you're going to do. Question presented. Our client, Jimmy Gilmartin, signed a lease containing several vague clauses, including one that requires him to obey all rules of the building and cooperate fully with the building manager. Do vague provisions, such as that one, make the lease void and unenforceable? So right there, you know, as the reader, okay, here's what the little question is about. I have a little bit of facts, and I have a general idea of what the law at issue is, right? Contract law, is the lease going to be void and unenforceable? And then short answer, no, and why not? No, because the lease is unenforceable if it describes the premises and identifies the parties, states the duration of the lease and the rental accounts, and is signed by both parties. By the way, rule explanation, one sentence rule explanation, followed by rule application. If those elements are present in the lease, other vague provisions will not render the lease unenforceable. Actually, that's all rule explanation. I think I would like it a little bit better if the short answer dealt a little bit more specifically with some of those facts that were described in the question presented. But in general, you see kind of rough length, 2 to 3 sentences. If you view the deep issue statement holistically, you see, okay, I now know what the facts of this case are, you know, in summary. I now know what the law is, the rule, in summary, and I now know how that rule is going to be applied to our facts. It's going to be applied to our facts in a way where the answer is no. Vague provisions, such as that one, do not make the lease void, bless you, unenforceable. So let's break this down in more general. Shelby Hall. So I kind of just said this, but let's recap. What are some things that a deep issue statement should have? That when you combine the question presented and the short answer, what should it have? What should the reader know when you're done? And by the way, something just like this is what your homework assignment is for you to write about Smith v. King.
They should know exactly what the question is that you're being asked and that you're going to answer, and they should know what your answer is and that you'll go into more detail later.
Yep, I think all of that's right. What else should they know? What else? They should know, Shelby told us they should know what the answer is. Should they know why that's the answer? Yes. Because if all I needed to know was what the answer is, this short answer would just be one word long, be no. But instead, you give a little bit of explanation of why. So it's going to have a little bit of law, a little bit of facts, and it's going to have a little bit of explanation of the answer. That's your deep issue statement. And all done, by the way, with cursive knowledge in mind. Your reader, you might think, okay, my reader has graduated from law school, but may know nothing about contract law, may know nothing about the facts of this case. Okay, what about the answer? So the answer for this one is no. I will suggest that usually your answer should say probably no or probably yes. If you're absolutely 100% certain, fine, just say yes or just say no. But a lot of legal questions, the reason you're investigating it is it's not entirely clear. And so when the answer is not 100% clear, this is my point. Don't communicate certainty that you don't have, or that you shouldn't have. And I will give you 2 examples of this. One is, there was an attorney in the Department of Justice named John Yoo, who the Bush administration asked to write a memo about whether or not the CIA could waterboard detainees. And there was a statute that said we're not allowed to torture, and so it seemed like the answer would probably be no. He thought the answer was yes. His biggest mistake was in saying the answer was definitely yes. Right? I mean, the memo still might have been unjustifiable if he had said probably yes, but it was what made it especially egregious is he made it sound like the answer was obviously yes. And so I wrote a memo myself, and I turned it into the partner, and I thought, I worked really hard on this, and I missed a great dinner, and was so excited about the dinner, I had to skip it. Wrote this memo, but I was all sure, okay, our client is going to win, and so I wrote this memo, and the partner was like, nice job in general, blah, 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 but this is not something I can turn into the client. Because remember, your audience is not just the 2 field, but if it's a sophisticated general counsel, frequently going to be forwarded to the client because that client's going to be interested in the question also. He said, this is not an open and shut case. We're not definitely going to win this case. And if we send this to the client, then the client is going to think, oh, well, we're 100% going to win. And then if we don't, that's a major problem. So first of all, it sets us up for failure. But secondly, it's just not, it's not as honest as it should be with the client. So when you're writing a memo, don't be an advocate. Pick what you think is the right answer, explain why you think it's the right answer, do that as persuasively as you can, but be transparent about counter arguments and any lack of clarity if there's lack of clarity. Okay. So Smith v. Kane, by the way, it's clear. It's okay if you say probably a due process violation, but it's also okay if you say definitely a due process violation.
She's at the door.
Ah! Hey, come on in. Now come on in. We're going to do an exercise and we'll...
Hello.
Hello.
I've raised... Okay, let's practice this. In 5 minutes, let's practice this, and then I'm going to turn it over to Kate. So here is your assignment right now. Write a deep issue statement, or the beginnings of one. Work with the person next to you to do this. And imagine that the partner or the supervisor comes in and says, I want you to write a memo about a covenant not to compete. What is a covenant not to compete? It's a part of an employment contract where the employer says, if you work for me and then leave, you are not allowed to work for anyone else. But there are limits to that because you're not allowed to just prevent that person from making a living. So there are 3 things that have to be reasonable about a covenant not to compete. The scope of activity restrained, so you can't restrain all work, you can only restrain work that is similar to the kind of work that you're being hired to do. The length of time, so you can't restrain someone from doing, let's say you're going to work for a pharmaceutical sales job. You can't restrain that person from doing pharmaceutical sales for the rest of their life. The length of time has to be reasonable, and the scope of geographic area has to be reasonable. You can't restrain them from doing pharmaceutical sales for the next 5 years anywhere in the universe. Has to be some limit on geographic area. Okay, here's the facts of our case. We're in Georgia. Everything about our case is in Georgia. Our client is a former employee who signed a covenant not to compete when the client took a job with the previous employer. It's a sales contract. So it says he can't do any sales. That's what the covenant not to compete says. For 3 years in 3 counties. 3 surrounding counties. And there's a precedent from Georgia. And here's what that precedent says. Restraining sales contacts, not contracts. Right? So you can't contact people for sales that you contacted in your old job. This precedent from Georgia says 3 things. Restraining sales contacts is almost always okay. It says that in this previous precedent, there was a covenant not to compete that lasted 3 years. That was okay. And there was a covenant not to compete lasting 3 years, restraining sales contacts that included up to 10 counties, and that was also okay. So that's the precedent. So work with the person next to you, spend 5 minutes writing a question presented and a short answer based on the facts of our case and this Georgia precedent that you can assume controls our case. 2 to 3 sentences for the question presented, 2 to 3 sentences for the short answer.
President? Question. The question.
What are we asking if they can get a job? What are we asking? Can
You're
they
asking,
get a job?
yeah, it's a good question. The legal question is, this covenant not to compete that our client signed, is it enforceable? Okay. And the precedent in Georgia says that that covenant not to compete that old employee signed was enforceable.
Yeah.
It's good. Okay. So, for question.
Did you get the precedents?
Yeah.
Okay, cool. 3 years, okay.
So for the question presented, we have who signed a covenant not to compete, 3 reasonable limits, the scope of activity enforceable. And that would pretty much be the question.
Yeah.
For the short answer. I don't know, it's just write it down.
Yeah, that's right now.
You wanna write it?
You can write on sales contract.
I'll put that in.
So our client
Signed a
covenant not to compete.
Right, and they're all
On
out.
sales
so
contract?
It's hard to go.
I'll put that in the
Okay.
original thing. Sign a covenant not to compete with 3 reasonable limits.
Okay, I started the first one in 3rd grade, but I had the benefit that when I started reading the
Scope
of activity
all of which I would
restrained.
say would be fine, especially if it's someone
2 is
who's
length
a
of
read.
time.
4th is where you start getting. 4th is where it starts getting heavy and dark.
3 limit on geographic area.
Now, 4th is where it starts getting heavy and dark, and so I had benefit that I was able to with the books. That is not an option now.
No, they're all out, the movies are all out. Right.
But yeah, if you can limit it to the first 3, I'd say go for it.
Yeah.
And lease is
given this.
so are you saying for our short answer we're starting? Oh no, that's the last
So then the
sentence.
question would be, is the
Yeah.
contract our client signed?
Or do the yeah.
Still need to pick the first.
It's just something
Based on like the limit. Do we even have to refer back to the limits? Or not?
Yeah, we'll have to talk about them in the
I'm saying in that last sentence.
the last sentence for the short answer. We'll have to talk about
We
them.
had a probably Dimitri.
Alright.
And if you were like had to stop mid-sentence, that's fine. You can just stop mid-sentence.
So starting with the question presented.
Yep.
Our client signed a covenant not to compete with 3 reasonable limits, the score of activity restraint, the scope of activity restraint, the length of restriction, and the scope of geographical restriction. Is the contract? Okay, and so.
Is the contract enforceable?
Yes, yeah.
Is the contract enforceable?
Sorry.
Okay. So
No,
good,
you
good
good.
last sentence, and then what's the short answer?
And then our short answer was probably yes. The contract would be enforceable in the state of Georgia due to the precedent. A contract restricting sales was previously okay, as well as a contract restricting an employee for 3 years, and then we were gonna keep going.
Good. So I think that
You're
Zach
good.
and Dimitri did a lot well there. A couple of suggestions that you might think about tweaking as if you were to like edit this and go with it, which we're not, just an exercise for this class. But you described the contract, our client's contract, as reasonable, which is correct. But that's kind of the legal question. So when you're doing the facts, don't make legal conclusions when you're describing the facts. Think of it as, if there's anybody who like watched the old Dragnet show or the Dragnet movie, there's this police officer who would always say, "Just the facts, ma'am, just the facts." So when you're describing the facts of the case, say, "Not a Dragnet fan?" You never heard of this?
No.
Has anyone heard of this?
No.
Emily, thank you,
I
Emily.
haven't.
Kate,
My dad
thank
loved
you,
watching
Kate.
it.
What'd you say?
My dad loved watching it.
Love
so
watching
I
it. It's a great show.
Sneak up and stay up.
Jack Friday, is the police officer. Anyway, the point is that just the facts. When you're describing the facts, do just the facts. And that's what you want to do for a question presented. See, if you look here, it's just describing the lease that Jimmy Gilmartin signed. So just describe the facts. It's okay to have a sentence of law in your question presented, but just don't confuse that. Don't intermingle it with the facts. I'll give an example of how this might have looked in the one we did. This is a little on the long side, by the way, so I'm not saying it needs to be this long, and there's some redundancy in it, but under the terms of a covenant not to compete, a former employee cannot do certain work in certain areas for a certain time after she leaves her job. Depending on your audience, maybe you leave that out. I mean, if you're dealing with a supervisor who deals with employment contracts every day, then you don't have to tell them what a covenant not to compete is. But know your audience and beware of the curse of knowledge. Georgia law requires the covenant to be reasonable with regard to the covered work, geography, and time. That's a statement of the law. You're not talking about the facts of our case, you're just like explaining the law. Now you're gonna talk about the facts of our case. Our client signed a covenant not to compete that prohibits her from making sales contacts last 3 years and applies to 3 counties closest to her employer's headquarters. Is this covenant not to compete reasonable? So we've got 2 sentences of law, 1 sentence of facts, and then the question. And so now that we've mentioned the facts and explained the law, the short answer is going to apply the law to the facts. Probably yes, and then we'll summary the law here. Several Georgia courts have held that covenants restraining sales contacts are nearly always reasonable. Georgia courts have also held covenants reasonable when the duration of the restraint was up to 3 years and when the area restraint included up to 10 counties.
Okay.
So a little bit of law, a little bit of facts, a little bit of rule explanation, a little bit of rule application. Do that for Smith v. Kane. Okay. Okay. Today's speaker is an outstanding attorney. I feel very lucky, first of all, to have Kate Costa